Good day and welcome to the review of the Equal Employment Opportunity chapter by Derek Crews. I want to highlight some of the critical information in this chapter, so let's get started. The first laws prohibiting discrimination go all the way back to 1941. 20 years later, in 1961, the Equal Pay Act was established. Of course, we're all familiar with the Civil Rights Act of 1964, which prohibits gender discrimination among many other protected groups. Today, women still make on average 88 cents for every dollar a man makes. Realistically, a woman would have to work all year and then until March 31st of the following year to make the same salary. Part of the gender pay gap goes back historically to the careers women were encouraged to pursue, such as a secretary or a daycare worker. Not every case where a man makes more than a woman in the same position is illegal. Those are called compensatory factors, and they could be defended in a court of law. Compensatory factors include education, previous experience, and job performance. Many companies are moving towards pay transparency, where salaries are available for public view. This is a step in the right direction to close the gender pay gap. The Equal Employment Opportunity Commission oversees the EEO. Equal employment opportunity prohibits discrimination in any terms and conditions of employment. Another term from our text is affirmative action, which is a proactive process whereby individuals are hired based on their protected class. Let's take the time to review the protected classes. Those include age, race, color, religion, national origin, immigration status, and disability. The Americans with Disabilities Act protects employees and potential employees, such as someone who may need an accommodation for an interview. You must provide it given the accommodation was made known to you. After the employee has provided medical documentation, an interactive process meeting occurs. Usually, that includes the employee, their supervisor, and someone from HR. The team sits down and discusses what the company can do so that the employee can perform their essential job functions. The accommodation must be reasonable and not put an undue hardship on the company. Here are some examples of reasonable accommodations that I was able to provide for some disabled employees. First of all, we had a person who suffered from migraines from the fluorescent lights. I found some covers that took away the sharpness, and then the employee was able to perform their essential job functions. Another example, we had an employee with arthritis. We were able to provide talk-to-type software so that this employee could do their job. One type of sexual harassment that is covered in our text is quid pro quo. That is when a supervisor offers a promotion or a pay raise for a sexual favor. A hostile work environment is where the environment is severe and pervasive with inappropriate language, jokes, ridicule, and even physical threats. It's an environment where an employee would feel abused and intimidated. There are many other types of discrimination found in the workplace, such as age and pregnancy discrimination. Unfortunately, those still occur in the workplace today. As future business leaders, we are all responsible for protecting our employees from discrimination and harassment. Our employees need to feel safe and protected. Thank you for joining me today for this review of the Equal Employment Opportunity chapter. Have a wonderful day.